Gary DeWaal here, and this is Bridging the Week for June 8th to 12th, and today is June 15th, 2015. Good morning. A United States federal court in Georgia enjoined an administrative enforcement hearing brought by the Securities and Exchange Commission on the grounds that the administrative law judge was appointed in an unconstitutional manner. On the other side of the Atlantic Ocean, the executive director of the European Securities and Markets Authority seemed to suggest that there was at least one important difference in the approach of the Commodity Futures Trading Commission and the European Commission in overseeing clearinghouses that could derail a necessary determination by the EC to avoid onerous capital charges by European banks clearing through U.S. clearinghouses. I'm working on some interesting articles, I hope, on cybersecurity and the new New York State BIT license requirements. So let me hurry through these important developments last week so I can get back to my writing on these other important, equally important matters. In other words, let's get started. The United Kingdom Fair and Effective Markets Review issued 21 recommendations to, quote-unquote, restore trust in the institutionally traded fixed income, currency, and commodity markets in the United Kingdom and globally. Among other things, the review recommended raising the standards, professionalism, and accountability of persons involved in FIC markets, strengthening regulations of FIC markets in the United Kingdom, and promoting fairer FIC market structures by increasing transparency and acting on anti-competitive structures and behaviors. The review was established by the Chancellor of the Exchequer in the United Kingdom and the Bank of England in June 2014. The review was co-chaired by representatives of the bank, the Financial Conduct Authority, and Her Majesty's Treasury. To achieve its objectives of restoring trust in FIC markets, the review recommended that the International Organization of Securities Commissions consider developing a set of trading practices standards that would apply across global FIC markets, potential UK criminal sanctions for market abuse be increased, qualification standards be required for market participants, and that public disclosure regarding market participants' disciplinary actions be enhanced. The review also suggested that there should be an examination of pay practices, quote, to improve the alignment between remuneration and conduct risk at a global level, and extensively discuss the impact of algorithmic trading on FIC markets. It is anticipated that the review's chairs will provide a report on the implementation of the review's recommendations by June 2016. A U.S. federal court in Atlanta, Georgia, ruled that an administrative enforcement proceeding by the Securities and Exchange Commission against Charles Hill is unconstitutional and enjoined it from proceeding. This is because the administrative law judge selected to hear the case was not appointed by one of the SEC commissioners, but hired instead by the SEC's Office of Administrative Law Judges. Thus, claimed the court, the ALJ selection violated the so-called appointment clause of the U.S. Constitution. The SEC had filed a complaint against Mr. Hill related to his purchase and sale of shares of Radiant Systems during June and July 2010, based on alleged insider information that Radiant would soon merge with NCR Corporation. Mr. Hill's victory may be short-lived, however, as the federal court also noted that, quote, the ALJ's appointment could easily be cured by having the SEC commissioners issue an appointment or preside over the matter themselves, end of quote. In a speech before the IDX 2015 conference in London last week, Timothy Massad, chairman of the Commodity Futures Trading Commission, suggested that the CFTC might apply a hybrid approach in connection with margin requirements for U.S. swap dealers executing over-the-counter transactions with certain non-U.S. counterparties. Under his proposal, U.S. swap dealers and non-U.S. swap dealers whose swap obligations are guaranteed by a U.S. person would apply foreign requirements in connection with margin they post with non-U.S. counterparties, but apply U.S. requirements in connection with margin they receive. Separately, last week, the European Supervisory authorities sought public comment on proposed regulatory standards on certain aspects of the European market infrastructure regulation, mainly the amount of initial and variation margin counterparties should exchange in connection with over-the-counter derivatives, as well as the criteria for acceptable collateral. Comments are due by July 10, 2015. Verena Ross, Executive Director of the European Securities and Markets Authority, urged the Commodity Futures Trading Commission to reconsider its position on margin requirements for house accounts of clearing members at clearinghouses in order to help break the impasse over whether U.S. oversight of clearinghouses is equivalent to European oversight. She made this suggestion during a speech at last week's IDX 2015 conference in London. Currently, the EC does not require U.S. clearinghouses does not recognize U.S. clearinghouses as subject to equivalent oversight. Potentially, this could require European banks to take onerous capital charges to maintain position through U.S. clearinghouses. Under the European regime, clearinghouses collect net margin from clearing members for both their house and customer positions, calculated on the basis that it takes at least 2 days to liquidate positions. In the U.S., margin is collected on a one-day gross basis for customer positions, but effectively on a one-day net basis for house positions. However, house positions in the U.S. include affiliated accounts, while in Europe, they only include positions of the clearing member firm. According to Ms. Ross, it was a pure lucky coincidence that when Lehman Brothers defaulted in 2008, the Chicago Mercantile Exchange Default Fund was not detrimentally impacted because, quote, the margins collected by CME on the Lehman's own account position were insufficient to close the positions without losses in 3 asset classes out of 5, end of quote. Separately, Ms. Ross indicated that ESMA is currently working on finalizing, quote, the world's most ambitious and comprehensive position limit regime for commodity derivatives to date, end of quote. She suggested that the scope of the European regime compared to the U.S. regime is, quote-unquote, vast. Whereas the U.S. is proposing limits on 28 core physical commodities, in the EU, said Ms. Ross, quote, we are talking about thousands of contracts, end of quote. And finally, speaking of position limits, the Autorité des Marchés Financiers, which regulates participants and products in France's financial markets, will implement reporting requirements and position limits for agricultural commodity derivatives beginning July 1st of this year. Under these requirements, any person holding agricultural derivatives on AMF-regulated market or a French multilateral trading facility or any foreign market that permits trading on contracts that result in delivery in France must daily report to AMF positions in excess of prescribed levels and are prohibited from exceeding specified position levels. These requirements are important to check out, and I report more on the article version of Bridging the Week on my website. Check it out. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Until next week, this is Gary DeWaal. Back to writing now for me. You have a great week, and ciao!